The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. We're here in the matter of State versus Courtney Hall. That will be submitted with oral argument in just a couple minutes. We also are having the following three cases submitted without oral argument at this time. Askvig versus Snap-on Logistics, McNaughton versus Chartier et al., and Carlson versus Second Succession et al. Those three cases are hereby submitted without oral argument. Case of State versus Hall. Mr. Sullivan, you may begin.
Good afternoon. May it please the court, counsel. My name is John Sullivan, and I'm an attorney practicing in Oline, Iowa. I was appointed to represent the appellant in this matter, Courtney Hall. Mr. Hall, just for a brief set of facts, Mr. Hall was convicted in a jury trial for 2 counts of suborning perjury and 2 counts of obstructing prosecution. Mr. Hall was found guilty, filed a notice of appeal, and the Court of Appeals affirmed the jury verdicts. Mr. Hall then filed an application for further review with this court, which this court has accepted. Mr. Hall is seeking, upon further review, dismissal of his charges for the reasons that there is insufficient evidence in the issue that I'd be discussing on the element of inducement, which is required for each of the charge, whether it's suborning perjury or obstructing prosecution. The facts of this case are...
You also kind of make an argument, which I'm interested in, about whether the suborning perjury applies, because is there a question whether was Mr. Hall really inducing somebody to conceal material facts as used in this particular statute, where allegedly what Mr. Hall was doing is trying to get the person not to show up at all, not to testify in a misleading way. So I'm interested in that issue of whether the statute criminalizes efforts to get somebody not to show up at all, as opposed to efforts to get somebody to be less than candid when they testify.
Yeah, and I would agree. I don't think that the statute for suborning perjury really applies there. I mean, especially in terms of these facts, they're very, they have 2 conversations, 2 separate conversations the day before the deposition where we're talking about he's telling her she shouldn't go to church that specific day, and then they keep talking about church, and then
Code.
I mean, whether or not it was code, I don't know if it really makes a difference, because
I was talking about church. I don't think we'd be here today.
what I'm saying is, even if he was talking in code, the question is whether or not he performed or there was any type of inducement. The Court of Appeals refers to that there was maybe some implied threat, that there was that there may not be the existence or a further relationship occur. But when one looks at the record, that wasn't a new issue. They've been talking about their relationship apparently well before this incident had happened. And I would submit that I don't believe that the statute or really the jury instruction really provides an idea that there could be some type of implied,
Your client was convicted under 720.3. 720.4 outlaws witness tampering. And the tampering, at least part of that, is to convince someone not to come testify. And so as I read 720.3, that doesn't deal with people not coming to testify. That deals with asking people to conceal facts known to them. And so what is your best argument that this isn't a concealment of facts? You know, in other words, why is this more properly thought of under 720.4, which wasn't charged, as I understand it, versus 720.3? What did the prosecution miss here?
the prosecution, I believe, missed is that there is no record evidence that Mr. Hall made any type of specific request of Ms. Bauer.
Has to be money or something tangible like that?
I look at it as, I think it should be, well, I mean, it's usually an if-then. If you don't, or if you do something for me, then I will or will not do something for you. Or if you do that, I am going to some type of overt threat or something of that nature.
Cutting through the argument, it seems to me there's a fair implication that don't go to church, meaning don't go to the deposition. And the implication is if you do, I'm going to withhold my affection or it's going to negatively impact our relationship. Challenge me on that characterization. Doesn't the record at least arguably support that characterization? A. And B, if it does, doesn't that lead to some potential jeopardy for you?
I don't believe that it does, because in the record, we learned that there was no, I believe from the testimony, well, I think the testimony was wishy-washy about whether or not they were actually currently in a relationship.
Joe, I mean, there's lots of dysfunctional relationships out there. And perhaps this exact type of, you better do this or I'm leaving you, maybe that's been the history of their relationship. So to say it's not new, is that really, does that automatically knock out that there could not have been any kind of influence by that or inducement?
I think that, I guess I would analogize it to a contract. Where's the consideration?
And you don't seem to be biting on the argument that I thought is raised in your brief, at least as part of your argument, which is even if there was an inducement, it was an inducement not to show up, not an inducement to show up and conceal material facts.
I would agree, even if there was, alternatively, even if there was an inducement, that's right, there was no record evidence that Mr. Hall and Ms. Bauer stated that he made no threats to her. He didn't specifically tell her not to show up. He didn't specifically tell her, don't say this or don't say that, or say this or say that.
Court, during trial, there was a record made regarding the instructions. The defendant submitted proposed instructions, but I couldn't find them in this record. Are they part of the record on appeal?
They're part of the record, Your Honor.
Correctly, the defendant did not object then to the instructions that were given.
I would agree with that.
At sufficiency, we're looking at sufficiency as measured by the jury instruction. Is that right? Okay.
About 720.3, and I agree with Justice McDermott. I was looking at 720.4, tampering with a witness, but that's not what was charged. So 720.3, isn't that kind of actually broken into two sections? There's the top half, which has to do with actual an inducement to make a statement under oath or affirmation, whereas the second half of it is, or who procures or offers any inducement to conceal material facts. So should we look at that as something different, the second half of that statute? Or do you think it's tied all to statements under oath or affirmation?
Well, I think the statute is referring to two situations. One where there's the actual, you make a statement under oath or affirmation. I'm asking you to either say something that may not be true. The second part of that statute is I'm asking you to keep something, under your sleeve and don't mention that. So it's kind of like a silent.
A person who they reasonably believe will be called upon for a statement in such proceeding to conceal material facts. I mean, one could argue that this is simply the other side of the same coin. It's kind of like what in fraud jurisprudence, there's sort of affirmative misrepresentation fraud, and then there's also fraud, material non-disclosure fraud, where you testify, but you say something that is in context misleading because it omits material facts. I mean, is that what this second part is about?
Right. I think, like in this case, excuse me, the facts show that she may have known, be able to identify some specific articles of clothing that Mr. Hall may have been wearing on a day in question regarding another criminal case. And if she had indeed known that, and he had asked her to just not say anything about what he was wearing, or that I don't remember. I think that's the second part of the statute. Yes.
If Mr. Hall knows she's been subpoenaed to go to a deposition and she doesn't show up for the deposition, is that one way that she could conceal material facts by not even presenting herself for the deposition?
I guess I would submit that would fit under the other statute that he was charged with, which was the obstructing prosecution. If he was attempting or seeking to have her, induce her not to appear.
And then the question I have on that one does that require actual non-appearance? Is that an attempt offense, or does that apply to actual non-appearance? I found an unpublished Court of Appeals case from about 10 years ago where the state apparently agreed that attempted inducement wasn't covered under this.
Yeah, I would agree that she would actually have to not appear. Otherwise, the statute, I don't think an attempt would be.
You know the record better than I do. When she did appear for that depo, is there any allegation that she was less than truthful?
No, not that I'm aware of. I believe she gave a truthful deposition.
Was the argument made at the district court that the subordinate perjury statute is inapplicable to a mere attempt to have them not show up?
I did not see anything in the record that would reflect that argument was made.
And then if, without objection, then the jury instructions would be law of the case, or they'd be controlling. Was there an argument made in district court that the obstruction statute does not apply if they show up?
I believe that argument was made. Mr. Counsel for Mr. Hall has made a motion for new trial, which was denied. So It's a general motion. Ladies and gentlemen, justices, I just, based upon the record and upon the application for further review made by the appellant, Mr. Hall would request that you reverse this matter and enter judgments of acquittal on all of these charges for the reason that the state did not prove that there was inducement or that there's no record evidence that he had made any threats, any promises, that he had asked her to conceal material facts or to not appear at the deposition. Thank you.
Thank you. Ms. Hines.
May it please the court, counsel? The state presented sufficient evidence to convict the defendant, Mr. Hall, of suborning perjury and obstructing of prosecution beyond a reasonable doubt. Both those crimes depend on the showing that he either induced or offered an inducement to conceal a material fact or to fail to appear when subpoenaed. And the state did that through the admission of videotaped evidence of conversations he had with the witness, his girlfriend, Emily Bowers, and her own testimony at trial about how she interpreted those conversations and what they meant.
Conflated the two statutes. The obstructing one covers failure to appear. The suborning perjury covers the act of inducing someone who you reasonably know will be making a statement under oath to conceal material facts, right?
I think that a way of urging someone to conceal material facts is by also urging them not to appear. And the fact that that happens to go to the same behavior doesn't.
Yeah, but you read the statute in context. It's one whole sentence, I believe, and clearly the first part is targeting affirmative misrepresentations by someone who does show up. You would agree with that. And the title is suborning perjury, and you would agree that we wouldn't consider what Mr. Hall did suborning perjury, would we, by any classical definition of that term?
Yes.
So given that, I mean, reading the statute in context and being aware there are other statutes that cover kind of the witness tampering, is this really covering, is it really, the concealing material facts, is it really talking about inducing somebody to not show up, so it doesn't even get to the point where they talk and might have to conceal material facts? You see, that's what I'm driving at.
This statute of suborning perjury in Iowa is incredibly broad, and I think there's a reason for that, and that is because the legislature obviously places a high importance on proceedings following.
Bowers voluntarily decided, without talking to the defendant, to not appear when subpoenaed. Could she be charged with perjury herself?
No.
Charged for suborning perjury for asking her not to appear?
Because because by asking her not to appear, he is asking her to conceal material facts.
Decides that she doesn't want to appear on her own volition without talking to him for the express purpose in her mind of concealing material facts. Could she be charged with perjury?
No, but because he did what he did, he can be, because he did, by encouraging her not to appear at her deposition, he encouraged her to fail not to appear, but also to conceal.
Perjury.
The language.
Be charged with perjury.
I don't think she could be charged with perjury, but I do think he can be charged with suborning perjury. I was to say that our statute is broad in the sense that in many of the states I looked at, in order to suborn perjury, you actually have to show that somebody perjured themselves. Our statute does not require that, and by the same.
our statute also says procure someone's non-attendance.
Offered inducement is what is the linchpin here, and that is what he did that is criminal. He
Physically restrained a subpoenaed witness such that she couldn't appear at trial. Is that suborning perjury?
I think that'd be tampering with a witness. It'd be chargeable under another.
For non-availability to conceal a material fact?
It could be, yes. Then I changed my mind.
I found a case from Minnesota and a case from New York, and in that case, the Minnesota case, for example, here's the, I'm quoting from it. The information charged defendant with an attempt to induce a witness to withhold true testimony in violation of Minnesota statute. That's their counterpart. The proof at trial established that defendant attempted to induce a young woman to absent herself completely and give no testimony whatsoever in an arson case in which it was then contemplated she would be called as a witness. And the court goes on to include that inducing somebody not to show up is not inducing a witness to withhold true testimony as covered by the statute. And that seems to me a better fit than concealing material facts. That seems, withholding testimony is closer to a no-show than concealing material facts. I mean, how do you stretch this statute to cover this situation?
I don't stretch it. I think that the defendant's behavior here was to achieve the goal of her not offering any testimony against him, not attending, and by not attending the deposition to do so.
The tampering statute, I'm just looking at the tampering statute right now, or to prevent such person from testifying or serving in such case. So you say that the suborning perjury statute is very broad, but does it need to be that broad when we know there's other statutes to pick up? Seems like what you're talking about.
Statutes, it's a broad section in terms of covering what is meant to be prevented here, which is encouraging and inducing a person not to appear or inducing a person not to provide facts for the proceeding.
And I believe the tampering's an ag, right?
Correct.
Is there overlap or is it being swallowed? I mean, what does 720.4 do then if 720.3 covers it?
Or explicitly prohibits bribing or threats. And there's other ways to get people not to appear or to testify negatively against you without bribing or threatening them. And that is actually the case here. This is a case of manipulation, and it's very clear when the tapes are watched exactly what the defendant wants Ms. Bowers to do, which is not to appear and not to offer testimony, to conceal material facts.
You're right. Correct me if I'm wrong, but 720.4 talks about the bribes first, and then it says, or who makes any threats, comma, comma, blah, blah, comma, comma, or to prevent such person from testifying. So it's more than just a bribe or a threat, isn't it?
I'm sorry, I couldn't.
That tampering statute starts off, you said it's only it talks about bribes and threats, which are the first two portions of it, but the third part, they're all separated with ors, is or to prevent such person from testifying or serving in such case. So doesn't it cover it?
It might cover it, but again, we have many crimes that.
Justice McDermott's, then it doesn't 720.3 swallow up entirely 720.4?
Let's see, 720.3, now I've lost my place. In 720.4, why am I not seeing it? Oh, here it is, okay. 720.3 is to conceal material facts known to such a person is the aspect of that crime that we're looking at. So yes, there is some, I'd say it's overlap. I'd say it depends on the circumstances of each case. But in this case, this defendant did everything he could to persuade, to induce Ms. Bowers not to reveal the facts she knew about this case. She was a very important witness in this case, and he found out about that 3 days, May 3rd, the day she was subpoenaed, he found out that she was going to provide crucial testimony to the,
I mean, this is a Class D felony with a 5-year sentence. And under the state's interpretation, if I just said to somebody that I knew was going to be a witness, gosh, you really would disappoint me if you showed up and testified. And that's enough to land me 5 years in prison, right?
here's what I would say to that is that you have to look at the entire context of the statement and the relationship between the parties.
Someone that I know well, and I say that, it would really disappoint me.
You who wants a relationship with you.
Very unhappy. And, well, I mean, but in a 5-year prison sentence, I mean, it just seems that isn't what the legislature had in mind. I don't know.
That may be problematic. I understand your concern, but that.
It's where they show up. I mean, it's just sort of a one-off conversation. I'm not saying those are the facts here, but that's exactly where your interpretation leads, isn't it?
Specific, and I think it's very, very much dependent on the relationship between the parties and the manipulation being used.
Obstruction charge for a minute. The jury instruction here required the state to prove that the defendant actually induced Ms. Bowers to fail to appear. Is that correct?
The jury instruction required, yes. It said that the defendant induced her to fail to appear when subpoena. Yes, it does say that.
Require that she actually not appear?
No, the induced part, I think, is what his actions are. We're talking about what his behavior is that's criminal, not hers.
Induce her. He did not actually induce her.
That is intended to be criminalized, much like pandering statute. You don't require somebody to actually commit prostitution when you persuade them to commit. Pardon me?
You look at the instruction for inducement. Where does it say it includes attempt?
It does not say that. It does not say that, but it's clear, I think, that the case law and the intent of the statute are to grab behavior that is deployed by the defendant, not the result. They're looking at the behavior of persuasion and inducement and not the result and outcome. Just because she happened to be an upright citizen and complete her duties doesn't take away from the criminality of him trying to get her not to do that.
Question I'd like to ask you that I asked of Mr. Sullivan. So she did show up for depo. Is there any allegation in the facts that she was less than truthful?
Mm-hmm. I want to return a bit back.
Reason that the defendant could not have been charged with attempt?
Well, I think that the way this statute's written, I mean, in a sense, it is the attempt. It's a statute that does include attempt, kind of as it's written. We don't have many attempt crimes in Iowa, but I think it's the actions of the defendant, which he did do here.
The instruction says the state had to prove the defendant induced Ms. Bowers, a witness with knowledge, to fail to appear, and that didn't happen.
I think we are interpreting induced differently.
Using the common interpretation, if I told my wife I induced our son to do his homework, I think she would normally think that he had done his homework. Not that I just asked him to do it, right?
I think in this statute, it's a term of art geared at the defendant's actions rather than the result.
It's a criminal statute, right? So don't we have to put this in favor of the defendant here?
Well, that's a rule of construction. Yes, I would agree with that, but I don't think that this is ambiguous. I think that when you're looking at someone's behavior aimed at preventing somebody from appearing to testify at a deposition, it's their behavior you care about, not whether it was successful. I mean, this man, I mean, I think we see in kind of in the third tape how much it affected her, how much pressure he was putting on her. And we don't want to encourage people to do all that they can up to the limit of somebody actually seceding to their.
Contacted somebody else and said, I would like you to talk to Emily and tell her that I don't want her to appear, and she still appears. So he's never communicated with her. Is that still induced as you're reading this statute?
It depends if there was communication about his.
Didn't pass along the message.
No, I think the communication probably has to do be with the witness with the knowledge that it's material. I think.
Ever affirmed a conviction for obstruction under this statute where the witness actually did show and testify truthfully?
That's a good question, and I can't answer it with any certainty. I could not find any, but I'm not sure my research was complete.
And on the subordinating perjury, have we ever affirmed a conviction where the witness, where the communication was aimed at getting the witness to not show up?
My research may not be perfect. I did not find anything.
Interesting academic question, but are we making an argument the defendant failed to make at trial? And if, okay, and is that an argument we should stay away from until it's full, wait for a case where it's briefed and argued below and we have a district court ruling?
I believe if this becomes an issue, it should be one raised in post-conviction proceedings because it was not raised at trial or in the briefing.
We can read the briefing to decide whether it's raised in the briefing. As far as whether it was raised at trial, the go-to would be the motion for directed verdict, right? We would need to go and see whether it's fairly included within the motion for directed verdict.
Certain it was not. The argument below, and I believe in the briefs, is that inducement of this nature was not sufficient to prove the defendant guilty of these crimes, not that she did actually appear or that she did not actually conceal material facts. That was not the argument made in the brief.
If our court wanted to decide this issue, would the state want to have the opportunity for supplemental briefing and or both sides? Okay.
Although I believe the best route forward would be to address this at a different proceeding in post-conviction when it can be raised in that manner rather than, pardon me?
You may sum up.
Thank you. The state respectfully requests this court affirm the convictions of the defendant for obstruction of justice and suborning perjury. He did induce the witness by his actions. It did not matter that she did not succumb to his wishes. Thank you.
Mr. Sullivan.
Thank you. I would just like to read the jury instruction, criminal jury instruction 4, induce, as it relates to suborning perjury. It says the definition for procure or induce. Procure means to initiate or bring about an event, to cause something to be done, to contrive or acquire. Induce means to offer something of benefit or value or a reason which would influence, persuade, coax, encourage, or invite a person to act. The jury instructions that were read to the jury, or the marshalling instructions for suborning perjury, indicated that on or about the afternoon and evening of May 5th, 2019, the defendant reasonably believed that a woman would be placed under oath to make a statement of fact, and number 2, the defendant, quote, procured or offered an inducement to the woman with the specific intent that she then conceal material facts known to her. I guess I would submit to the court that the state did not for the arguments made today and in the brief, the state did not present sufficient evidence that Mr. Hall had procured or induced Ms. Bauer to do anything. Going back to Justice Manfield's example with his son, when I think of the same thing, well, I may not use the specific word induce, but, if my wife knows that my son did the dishes, yeah, I induced him to do the dishes. She knows that, okay, what'd you give him? An extra hour on the Xbox or whatever it was. And there is something there. There's something specific. The record in this matter does not reflect that there was any type of specific action by Mr. Hall, that there is any type of procurement or inducement to get her to conceal any type of material fact.
For which the defendant moved for directed verdict.
I believe that the defendant moved for directed verdict. I believe it was boilerplate. He moved for directed verdict that the state did not present, even looking at the evidence in light most favorable to the state, that they didn't support the elements with regards to inducement or procuring.
Counsel, are you aware of any Iowa cases where we held subordinate perjury does not apply to an effort to get the witness to not show up to testify?
My research, I'd agree with the state, I've not been able to find anything that would, this is, and I think that's maybe one of the reasons we're here, is that there's really not much on these statutes. In summary, I just indicate that I believe that the state did not meet its burden on these matters, that there's not one I would submit to you that there's not one shred of evidence in the record that Mr. Hall did anything to induce for the purposes of subordinating perjury or obstructing prosecution. I mean, Ms. Bauer, as it relates to obstructing prosecution, she showed up. And the record reflects that there's nothing in the record to indicate that she gave untruthful testimony. There's nothing in the record, again, to reflect that he induced her to conceal any type of material fact as it regards to perjury. And I'd ask the court to vacate those convictions and enter dismissal of the charges. Thank you.
Versus Courtney Hall is hereby submitted, and we are adjourned for the day. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.